Good morning and welcome to the Madrona Group's 15-minute forms, where we pick a form to talk about for about 15 minutes in hopes to develop a better understanding of it and how to use it in our transactions. Today, I wanted to talk about referral agreements and disclosing all of our compensation. So why am I even talking about this? Well, after the NAR lawsuit was settled, the rest of the country applied the rules of the settlement to their practices. It was determined that we had to get more specific and transparent to both buyers and sellers about our compensation and make sure that our compensation was known as fully negotiable. And not only that, but it was a clear choice of conversation when we talk to our clients and clear to the other parties. Excuse me. So years prior, the Northwest MLS had already started making these changes for transparency of compensation. And they did this in a more widely known way by updating the listing agreements, the buyer agreements, by removing what we used to do as combined compensation and creating a very distinct differentiation between buyer compensation and seller compensation for the agents. Our listing agreements now have a clear choice that sellers can check, and it includes a disclaimer that says it is not required by law for the sellers to offer a buyer broker compensation. Our buyer agreements were also made very clear at the time, this was around January of 2024, that any compensation not offered by the seller would ultimately be the responsibility of the buyer. And at that time, we also had to determine what that compensation amount was going to be before we wrote up offers. This is the rule that's kind of still in place. So when we look at our buyer and seller agreement, we see that a predetermined number has to be chosen in there. It cannot be arranged. So the rule surrounding this compensation basically is that all offers of compensation must be disclosed in the purchase and sale agreement and to any party we represent in a transaction. So what constitutes all offers of compensation? What do we need to disclose? Kind of in the basic overview of this, we know that we need to disclose buyer compensation for the buyer agent, seller agent compensation. But did you know that there's also a need to disclose things like what you're receiving for dual agency? If you are a dual agent, that full amount of compensation has to be transparent in your purchase and sale agreement. And this includes any bonuses an agent may receive for selling a specific property. But what happens if you're paying or receiving a referral fee to help a client? Because that is a transfer of compensation, and we never really had a place to put that. What about if you're a listing agent and you don't have permission to be a dual agent, so you're referring another agent and then receiving a part of that agent's compensation for that referral? You're technically going to get paid a different amount than that client of yours is aware. Any of these situations do count as yes. We have to disclose all of these things. Our clients are required to know how much we are being paid and where it's coming from. And the reason for this is because we are now leaving the responsibility of compensation to the clients in the ultimate case. With the new changes and putting all the responsibility back on the buyer, say, if there's no compensation offered, then the buyer should know exactly how their obligations are going to be met and if there's going to be any other additional to help meet those requirements. So how do we start this? Well, this starts with a referral. I'm going to talk specifically about referrals today. The referral form is Form 11, and I've posted it on the right-hand side of this page. Now, when you're doing a referral, if you are receiving or giving a referral, our firm address is going to be our corporate address. That is going to be this Linwood address that I've put down here. You can find this address on our website. If you can't remember what this is, feel free to jot it down right now. But the firm itself is the Madrona Group. We are John L. Scott, the Madrona Group, and our firm is licensed under the name the Madrona Group, Inc. So if you are doing a referral, it is going to go to or from the Madrona Group, Inc. at this Linwood address. So step one is to fill out the referral form. The new part is here. The referring firm will sign the referral consent form with the client who's being referred. The client will see the referral amount and who will be paid in the event of a closed transaction. This must be signed by the client in order to validate your referral. These forms are new as of last month, July 2025. So please be on heightened awareness of this new process. These forms will be held with your referrals in your brokerment file. What this form does is it shows the client who the referring agent is, the amount that's being referred for, and then it has a place for both the buyer or the referring broker firm and the referring broker's signature. This means the broker who's referring signs it, as well as the managing broker or the designated broker. The acknowledgments below are going to be from the client who is being referred. The client needs to be aware of the referrals that are transferring back and forth. Once you receive the referral, you will sign your buyer agreement or your seller agreement to begin giving your brokerage services to your new client. These forms are your 1A and your 41. So this is the new paragraph in the 1A, which is the listing agreement. It's paragraph 8, and it has a place to disclose if any referral monies are being transferred back and forth. It has a checkbox option that the listing firm is or is not obligated to pay a portion of that listing firm's fee to a selling firm, and that the seller consents to the listing firm receiving a portion of the listing firm compensation, in which case you are going to rewrite who the referring firm is, what the referral fee is. These listing agreements have this new space. Remember, we are no longer lumping our compensation together. We have now decoupled our compensation. So all offers of compensation in any form whatsoever must be disclosed. The buyer agreement, Form 41, also has a space to disclose the referral compensation in paragraph 8 as well. Any referral being paid out is required to be disclosed here. If you notice, it says the buyer brokerage firm is not obligated to pay if you don't check the box. If you leave this blank, that referral fee is not an obligation. The listing agreement also has the same thing that says the listing firm is not, if not filled in. So what if I receive a bonus? There are all types of ways that sellers can incentivize people to buy homes. Sometimes you'll have a builder bonus that'll say something to the effect of buyer bonus, blah, 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 or extra compensation for the agent who sells this particular home. It doesn't happen very often, but it might happen, and it has happened in the past. If there's any other type of compensation that's being paid to the broker, it must be disclosed in the blank space in your agreement with your client. That is your client, whether it's buyer or seller. Sellers sometimes offer a bonus for agents to sell certain homes, and if so, that must be disclosed to the client. If a broker has a chance to win a prize or a vacation or some other drawing that would benefit that agent, that must also be disclosed. Remember, the rule was created around open transparency to our clients. So we as agents are under the obligation to not accept more compensation than agreed, and then our agreement states. So if you are receiving anything more than agreed, you need to make your client aware of this and get consent. Any additional amount received will be seen as a benefit to you and not your client. Your duties are to do no harm or to do nothing to your client's detriment, and you are not allowed to accept more compensation than you have agreed. And if you do accept compensation more than you've agreed, then are you doing your client a disservice by accepting that and not mentioning it? Remember, this rule is all about transparency. So anytime money is being transferred back and forth, make sure you have documentation of that and you have your client's consent to receive it. If you have questions about disclosing your compensation, feel free to reach out to your managing broker, or you can reach out to me.